Thank you very much, everyone, for being with us today. As I think most of you know, this event is part of a virtual conference. This conference really is organized around commemorating 70 years of the existence of the United Nations High Commissioner for Refugees. It is organized in the main by the Global Academic Interdisciplinary Network, GAIN, and GAIN has chosen a number of partners with whom it presents this virtual conference. There are plenary sessions, and then there are these side sessions that focus on particular regions in the world. So we, as the Center for Human Rights at the University of Pretoria, we are very pleased to be collaborating with GAIN and in hosting particularly this session on Southern Africa and its engagement with the Office of the HRC. So the event itself spans 4 days. It started on the 18th, it will be today, also on the 21st and the 27th. So we implore and invite you to attend other events. This morning, there had already been, at least from our perspective, and part of the events focusing on East and the Horn of Africa. We have this event, and then there will be side events focusing also on Europe, Latin America, and tomorrow on the 21st on Asia, Pacific, the Middle East, and North Africa, West and Central Africa, and North America. So there are these series of events. We once again welcome you at this particular one, which focuses on Southern Africa. As you know, GAIN is focusing on the implementation of the Global Compact on refugees, and it is within the ambit of also the work in raising greater awareness around the issues and also the Global Compact that this event takes place. Now, we have 3 scheduled speakers that you would have noted from the program. Our one speaker is not yet able to join us, but we will start with the second speaker on the list, and hopefully we will be joined by the first speaker. Briefly speaking about Southern Africa, I think if we look at the emergence of issues around forced displacement, refugees, issues, Southern Africa comes to mind often in the context of migration linked to labor migration. South Africa obviously is a center point within Southern Africa, but we also know that in terms of conflict in the region, that we also have seen particular events leading to migratory movements, in particularly around political instability in Zimbabwe and in the Democratic Republic of Congo. So we welcome you and thank you for your interest in this topic. We'll have our speakers present for around 15 or to 20 minutes, and thereafter the floor will also be open. We invite you to post your comments and questions in the chat room. So the first speaker will be Dr. Cristiano Dorsi. As the Center for Human Rights, we are fortunate also to say and lay claim to Dr. Dorsi. Has been a postdoctoral fellow with us here at the center. He certainly is a great expert in migratory movements and the rights of persons who are refugees, internally displaced persons in the African context in Southern Africa. He now finds himself at the University of Johannesburg, where he researches and lectures, and we thank him very much for agreeing to also be with us today. He will speak about protecting refugees in Southern Africa, reflections on the complementarity of the United Nations Refugee Convention and the OAU Convention pertaining to refugees. Thank you very much, Dr. Dorsi, and we hand over the floor to you.
Thank you so much for the invite, Professor Viljoen, or Frans, in fact, allow me to call you Frans as you call me Cristiano. It's a great honor to be part of this event, in fact, that is spanned for the entire globe. Yes, my presentation, I will start briefly to speak about the relation between the 51 Refugee Convention and the OAU Convention, and afterwards I will do 2 with very short examples in Southern Africa. One, of course, is South Africa, and one that, in my opinion, is very interesting is what happened in Malawi that recently held his last presidential election in 2020. The OAU Convention, as you probably many listener knows as well, complements the 51 Refugee Convention and its 1967 protocol, which remain the universal and primarily legal protection instruments for refugees. Paragraph 9 of the preamble of the OAU Convention refers to the Refugee Convention as modified by the New York Protocol as the basic and universal instrument relating to the status of refugees, and Article 8, Paragraph 2 of the OAU Convention affirms that this last instrument is the, I'm quoting, effective regional complement of the Refugee Convention. Of course, several conclusions of the Executive Committee of the UNHCR also reaffirmed this relation between the two instruments, the universal one and the regional one. The first one to reaffirm this relation was the conclusion number 87 in 1999, that at paragraph F affirmed that the 51 Convention and its protocol remain the foundation of the international refugee regime. However, there may be a need to develop complementary forms of protection, and in this context, UNHCR encourage, in consultation with states and relevant actors, to examine all aspects of these issues. There were several executive committee conclusions dealing with that, but one of the last was the conclusion 103 of 2005, that at paragraph F, I'm quoting, the EXCOM call on states to make maximum use of existing protection instruments when addressing international protection needs, and encourage states that have not already done so to consider accession to the 51 Convention and 67 Protocol, and to relevant applicable regional instruments, and or to consider lifting existing limitation or withdrawing reservation in order to ensure the widest possible application of the protection principle they contain. The OAU Convention incorporates in its Article 1, Paragraph 1, the Refugee Convention definition of a refugee contained in Article 1A2 of the Refugee Convention, as amended by the New York Protocol, and also elaborates on its application in different contexts. A principal purpose of the OAU Convention is to provide refugee protection in specific humanitarian situations, including large-scale arrivals of people fleeing situations or circumstances in their country of origin, which fall within the OAU Convention Article 1.2 criteria. Contrary to Article 1A2 of the Refugee Convention, Article 1.1 of the OAU Convention does not include the temporal limitation of having a well-founded fear as a result of events occurring before 1st of January 1951, a limitation that was later removed with the adoption of the New York Protocol. In applying Article 1.1 and Article 1.2 of the OAU Convention, the primacy of the Refugee Convention needs to be recalled, given its central legal position as the basic and universal instrument relating to the status of refugees, which is explicitly acknowledged in the OAU Convention itself. The OAU Convention, by contrast, addresses specific challenges faced by African countries in responding to refugee crises on the continent. Most factual scenarios suggest the relevance and applicability of both the Refugee Convention definition and the OAU Convention Article 1.2 definition to a person claim for refugee status. In limited situation, an individual may be a refugee under Article 1.2, but not under the Refugee Convention definition, including where no causal link can be established between his fear of being persecuted and the Refugee Convention ground. In such circumstances, Article 1.2 expand the potential range of persons eligible for refugee status. In comparison to the Refugee Convention, the OAU Convention contains a more limited set of rights for refugees, ranging from protection from refoulement, voluntary repatriation, and the issuance of a travel document. The OAU Convention does not, unlike the New York Protocol, explicitly incorporate the entire standard of treatment found in Article 3 to 34 to the Refugee Convention. For most refugees in Africa who are recognized under the OAU Convention, the limited package of rights included in the OAU Convention does not pose a significant problem in practice, as the majority of the African Union member states are party to both the Refugee Convention and or its New York Protocol, as well as the OAU Convention. In these countries, refugees recognized under the OAU Convention, whether under Article 1.1 or Article 1.2, benefit from the Refugee Convention's right framework. OAU Convention refugees and Refugee Convention refugees are similarly situated, with indistinguishable status attached, regardless of the legal basis of their protection needs. A difference in treatment would be neither reasonable nor objectively justified, would disregard the complementary character of the OAU Convention and would amount to discrimination. Moreover, the preamble of the OAU Convention recognized the need and desire to establish common standards for the treatment of refugees. To date, of the African 54 member states, no country from Southern Africa have neither signed nor ratified the Refugee Convention and its New York Protocol. These states are also party of the OAU Convention. To specify, according to the geographical division made by the African Union, Southern Africa includes 10 countries. They are the following: Angola, Botswana, Eswatini, Lesotho, Malawi, Mozambique, Namibia, South Africa, Zambia, and Zimbabwe. Under the heading Asylum, Article 2 of the OAU Convention obliges EU member states to use their best endeavors consistent with their respective legislators to receive refugees and to secure the resettlement of refugees who are unable or unwilling to return home. The ultimate goal of international protection is to achieve durable solutions for refugees. The OAU Convention foresees in this regard the voluntary repatriation of refugees to their country of origin, as is set up by Article 5 of the OAU Convention, on the resettlement in the asylum country or in a third country of refugees who are unable or unwilling to return home. Of particular importance for the settlement of refugees are the granting of a secure legal status and a progressively wider range of rights and entitlements that they are broadly commensurate with those enjoyed by nationals of the host country. The Refugee Convention, the OAU Convention, and human rights instruments provide a useful legal instrument for a legal framework, for this. Under international law, a state is required to ensure the effective implementation of its international legal obligation in good faith. In this regard, the OAU Convention requires EU member states to provide information to the EU on the condition of refugees, the implementation of the OAU Convention, and more broadly, on the laws, regulations, and decrees in force relating to refugees. In addition, EU member states are obliged to cooperate with UNHCR, including to ensure that the OAU Convention is the effective regional complement in Africa of the Refugee Convention, and to allow UNHCR to exercise its international protection function under its mandate, including in countries that are not part to the Refugee Convention or to the New York Protocol. But we have seen that this is not the case for Southern Africa, because in Southern Africa, all the 10 countries of Southern Africa are both party of the Refugee Convention, the New York Protocol, and the OAU Convention. Speaking a bit in general about South Africa is party to the Refugee Convention and to the OAU Convention since 1996. On December 27, 2019, the South African Department of Home Affairs published finalized refugee regulation that enabled implementation of the Refugees Amendment Act effective January 1st, 2020. The Refugees Amendment Act drastically limits the right of refugees and asylum seekers in South Africa, traditionally as a place of refuge for Africans from throughout the continent. Under the new regulation, refugees, for example, can lose their refugee status for voting or participating in any political activity in their countries of origin, preventing refugees from protesting against abuses in the countries for which they have fled. However, South Africa Bill of Rights, that is contained in the South African Constitution, specifically confers the rights to opinion, expression, and association upon everyone. Critics of the new regulation have pointed out that South African refugees and exiles who organized themselves from abroad were crucial to the anti-apartheid movement, for example. The new regulation also includes other grounds for the loss of refugee status, including if a refugee seeks any consular services from their country of origin. This could mean that an act as simple as requesting a birth certificate at a consulate could trigger a withdrawal of refugee status and possible deportation from the country. These rules thus could violate the right of non-refoulement, an established principle under the International Refugee Convention, which holds that a refugee should not be returned to a country where their life or freedom would be threatened. Civil society and refugee assistance organizations in South Africa expressed grave concern at the new law. With a backlog in asylum application and recent waves of xenophobic violence, the situation of asylum seekers and refugees in South Africa was already precarious. By making asylum more difficult to obtain and keep, the new refugee law places asylum seekers and refugees in South Africa in an even more vulnerable situation. Finally, I would also a bit highlight what's happening in Malawi. That it's a bit neglected sometimes when we speak about the refugee protection in Africa. Malawi is a party of the Refugee Convention and to the OAU Convention since 1987 and held the last presidential election in 2020. According to the Refugee Convention, Malawi made reservation to the following articles of the Refugee Convention. Article 7, exemption from reciprocity. Article 13, movable and immovable property. Article 15, right of association. Article 19, liberal profession. Article 22, public education. And Article 24, on labor legislation and social security. The government of Malawi intimated that it considered the above as mere recommendation. They do not have binding efficacy to Malawi as a refugee hosting state. Malawi also indicated that it reserved a right to limit enjoyment of the right to wage earning employment, Article 17 of the Refugee Convention, and to freedoms of movement and choice of place of residence, Article 34 of the Refugee Convention. In 1989, Malawi passed the Refugee Act, which provides for the receiving, admission, and treatment of refugees and the application of the international instruments. The 1994 Malawi Constitution recognized international law and contains a Bill of Rights applicable to all people of Malawi. Despite having such a regulatory framework in place, the country continues to experience a number of challenges in relation to protection and assistance to asylum seekers and refugees. These are resulted in call for a review of existing policies, laws, and practices affecting refugees. That is also something that we have seen in the EXCOM decision, for instance. In 2018, the Malawian government accepted to roll out the comprehensive refugee response framework under the New York Declaration of 2016. This is a key achievement as it would enhance harmonious coexistence of both refugees and asylum seekers together with nationals. Under the comprehensive refugee response framework, the country intends to implement activities that will foster the following: include refugee national system, especially in health, education, and security, legal and policy reform, registration and documentation, enhanced reception condition, and increased livelihood opportunities. The government has in the past initiated a complete review of its refugee policies and the refugee law leading to the mentioned draft refugee law. But UNHCR actively supports this process and views it as a positive step and a display of the willingness by the government of Malawi to improve the human rights situation for persons seeking international protection in the country. However, UNHCR notes, on the other hand, that the draft of the new refugee law has been under review for the past 8 years. In accordance with government procedure, the draft act will be enacted after the related refugee policy, which is contained in the national migration policy, has been endorsed by the government. The migration policy has introduced other areas, including statelessness and internally displaced persons, that were never covered as well in the old refugee law. The 9 reservations Malawi made to the Refugee Convention, in fact, on the other hand, exist only on paper. In practice, refugees in Malawi own property, form association, engage in wage-earning employment, and practice their profession, mainly as teachers. And some of the refugee children attend public school in Malawi. The government of Malawi should probably thus be encouraged to lift this reservation, even formally. In addition, the reservation to Article 26 of the Refugee Convention on freedom of movement and choice of place of residence greatly hampers and affects prospects for social reliance and livelihood. Refugee asylum seekers are mainly hosted in Malawi in the Dzaleka refugee camp that is close to Lilongwe, the capital. The government of Malawi has an encampment policy which restricts refugees from certain rights, such as access to tertiary education and formal employment. The Dzaleka refugee camp accommodates over 44,000 people of concern as of November 2020, but it was originally established to host 10,000 individuals. The camp is therefore congested and overcrowded. But the government is making another effort, providing additional land space adjacent to the existing camp called Katubsa and Dzaleka Hills, aimed at reducing congestion in Dzaleka camp. Malawi also continues to receive asylum seekers, but at a reduced rate of less than 100 per month since the onset of the COVID-19 pandemic, notably due to the restriction on crossing international borders. The new governor of Malawi has expressed its strong commitment to rolling out the comprehensive refugee framework. President Lazarus Chakwera has announced that the functional review of the refugee response will be conducted in 2021, along the development of a national migration policy. In 2021, in fact, and I'm almost done, the Malawian government will focus on strengthening the operational response to minimize the transmission of COVID-19 among people of concern, efforts to adopt prima facie refugee status for Congolese asylum seekers from North and South Kivu and from Katanga region, make efforts to the inclusion of refugees in the national health and education sectors, efforts to decongesting the Dzaleka refugee camp by relocating refugees to the newly developed Katubsa and Dzaleka Hill sites, and finally, efforts in expanding livelihood activities aimed at empowering people of concern and achieving self-reliance. Thank you so much for the attention, and I will be looking forward for possible questions. Thank you.
Thank you very much, Cristiano, Dr. Dorsey, for giving us that overview really of the legal framework, but also focusing on the intricacies of its application in a country like Malawi, which I think was very insightful. We now turn perhaps to a more political science-focused presentation. It is our colleague here at the University of Pretoria, Dr. Chris Nshimbi, who will take the floor. Dr. Nshimbi is with the Governance Integration Unit, this Center for the Study of Government's Integration here at the University of Pretoria, GovIn. His area of expertise and focus is around governance and transboundary aspects of governance. Dr. Nshimbi has worked and lectured in Zambia. He joined this center at the University of Pretoria and is also teaching in the Department of Political Sciences at the University of Pretoria. Thank you so much for agreeing. He will speak on the topic slightly adjusted from what was perhaps earlier advertised. Dr. Chris will speak on migration governance and the protection of refugees and migrant workers in Southern Africa. Thank you so much, colleague.
Thank you so much, Prof. Viljoen. I'll show my face just briefly, then I'll turn off the video for because of bandwidth issues. So that's me there. My name is Cristiano. I'm at the University of Pretoria, as introduced. My video is off now. As said, I'll briefly just talk about migration governance and the protection of refugees and migrant workers. And I know we are talking about the UNHCR here, but I'll try to clarify just briefly why I am talking about migration governance. And it's within the context of Southern Africa. And when I say Southern Africa, I refer to the 16 member states of the Southern African Development Community. And the reason why I look at it in that context, because these 16 member countries subscribe to a common treaty and also to many and various other instruments, which I will highlight in my second point. So basically, I'm going to talk about three things or touch on three issues. First, I'll just try to make some conceptual clarification. I won't go into details, just to clarify. And then I'll talk about the governance and protection frameworks that exist in the SADC region. And then I'll end with the solutions, basically, which point to the challenges that refugees and migrant workers face in this region. So by way of background and also maybe some kind of conceptual clarification, first, of course, I'll point out the fact that migration in the Southern African region or in the SADC region is a historical reality. It's something that occurred pre-colonial. It occurred during the colonial period, and it's still occurring in the post-colonial period. And of course, by migration, in terms of definition, without giving full definitions, but I'll just point out the fact that when you look at academic circles, they have their own definitions, and also the international organizations or institutions like the UNHCR, IOM, etc. They have their definitions. But what you can actually catch or grasp from the essential elements in these definitions is the fact that they talk about people's usual residence, and also changes that occur in people's usual residence, and also the duration of time they spend in a place which is not their original or country of citizenship or nationality. And you will see that actually there is a tendency of late in especially the academic literature to move away from migration to start talking about these realities in terms of mobility. So there's an effort or trends to start to talk about mobility broadly and not specifically migration. So why do I refer to migration when we are talking about refugees, or more precisely, we are talking about issues of displacement? The UNHCR, of course, has its own definition of refugees. And but still, when you look at that definition, you will see that it still touches on issues of people living outside their country of nationality. But of course, attached to that, there's the issue of having well-founded fears for not living in their country of nationality, and of course, being persecuted in that sense. Okay, so when you look at those issues, bringing together the definitions from various international organizations as well as the academia, and then you try to apply that to the Southern African region, you find that actually there are various forms of displacement that occur in the region in Southern Africa. So there are displacements that are motivated or induced by conflict and war. We speak about issues of violence, we speak about issues of trafficking in people, etc. So those who make people move around. Then there are also social cultural issues and factors that will cause people to move. And here we can even talk about issues that relate to the violation of people's human rights. They will be forced or induced to move because of that. And then also there are disasters, or you could call them environmental factors, but generally you talk of disasters and maybe climate change related migration. Although within the SADC region, this has not yet fully received attention, but there's at least a bit of movement towards recognizing that there are people that some scholars will clearly call it environmental migration. Yeah. So the other point that I would make here is that all countries in this region that I'm talking about actually host asylum seekers, refugees, and migrants. I know if you read the common literature there, you get the picture that everybody is moving towards South Africa. Much as South Africa is an economic hub of the region, and of course there are substantial numbers of people that migrate to South Africa, but I think a disclaimer has to be made that all countries in this region host asylum seekers, they host refugees, and they host migrants. And some of these realities are brought to light, especially when you have cases where, for example, Angola a couple of years ago deported a number of Congolese who were actually seeking asylum in the country. That's when you begin to realize, to say, oh, even countries like Angola actually host refugees from the region. So the reason why I use the term refugees and migrant workers are not just refugees only, and it touches on why, at least on this explanation that I've given, to say each and every country in the region does host these categories of people. The reason is simply that when you look at the Southern African region, actually it's very hard to point a finger to say this kind of movement that you are seeing is people seeking asylum or people seeking work. Okay, so you have mixed migration, which actually coexists with claims of asylum and informal cross-border flows. So you would find it surprising sometimes that you find a person that is crossing a border, they are engaged in informal cross-border trade, but then the next day you find them working on a farm. They become a migrant worker. Or the next day you find them at a refugee reception center, they are applying for asylum. And yet when they were crossing the border, they were an informal cross-border trader. So it's very difficult to make a distinction. And in fact, maybe I should have said at the very outset that when you look at migration in Southern Africa, it should be understood and also examined in the context of what happens on the continent as whole. So Africa is a continent that has a very complex migration dynamics. The migration on the African continent is characterized by diverse migration patterns and, of course, a long history of intra and inter-regional migration flows. And maybe, again, just to emphasize also here that it's not a continent that is on the move to Europe. A lot more migration happens within, or a lot more mobility happens within the African continent than people that are trying to get out of the continent to go outside of the continent. So if that's the case, how does the continent and how do the regional economic communities govern migration or the mobility of people on the continent. So this brings me to the second point, which basically is about governance and protection frameworks. So at the continental level, you find that the African Union has a common position, and of course it has adopted several policy frameworks that will support the ideal of free movement. So you have, for example, the African Charter on people's and on human and people's rights, just to list some of them. And then you have the African Common Position on Migration and Development. There's also the African Migration Policy Framework. And of course, the very latest is the Migration Protocol of 2018, which was signed in Kigali, basically which seeks to promote free mobility or free movement across the continent. But in relation to the subject that we are talking about today, there's of course the OAU Convention that governs the specific aspect of refugee patterns in Africa. So at a continental level, broadly speaking, that's what you find in terms of the framework that governs the movement or mobility of people. When you come to the regions, I'll restrict myself to the Southern African region, but you find that when you look at the continent as a whole, there are a lot of disparities in terms of approaches that regions adopt in order to manage the movement of people. But when you come to the SADC region, of course, there is a treaty, or the SADC treaty, which basically aspires to achieve free movement of people across the region. But you will see that, of course, there's a protocol that has been drafted which is supposed to encourage free movement, but that protocol has not yet been ratified. So in its absence, you find other instruments that will govern the movement of people in the region. But you will see also that the region seems to, of late, be tending towards trying to just facilitate the movement of people. And also it's kind of focusing on issues that relate to fighting trafficking and so on and so forth. There's of course the Declaration on Refugee Protection within the SADC, and it has a number of commitments, and most of these commitments basically are kind of reflective of the OAU Convention governing specific aspects of refugee problems in Africa. So for example, they say at the outset that they reaffirm the OAU Convention, and then of course they commit to addressing the root causes of refugee movement, and also issues like averting the flow of refugees and so on and so forth. So that's a declaration, but this is some kind of a soft law in the sense that it is not binding. It's just a declaration, as it says. And not only the fact that it is not binding, also when you look at other instruments that seek to speak to the issues of refugees and migrants, you find that most of the countries in the region actually have not ratified or signed those instruments. So there's a sense in which there's a lack of commitment in that sense, in terms of signing and ratifying, so that they can adopt them, or at least they can integrate them into their national policies and legislations. But when you come at the national level again, you see that there are legislations on various migration-related issues in the 16 member countries of this region. So they will have legislation on, for example, citizenship. They will have legislation on immigration. They have legislation on asylum or visa issues. But there is a sense in which you won't find specific policies that are dedicated, for example, to addressing refugee issues, or to addressing migration itself. Some countries actually don't even have a migration policy. So that's one of the challenges that you find in this country. So there's nothing that is really or clearly directly addressing the effective protection of people who are forcibly displaced, or of migrant workers against exploitation or criminal activities and so on and so forth. So this leads me to my third point to say what solutions or suggestions can be made in order to enhance governance and also protection of refugees and migrant workers. You see that I haven't gone into discussing the challenges that these people face. And basically the solution themselves will speak, or at least they point out the challenges that refugees and migrant workers face in their host countries. And there are very many of them. I was just earlier trying to tabulate them and I ended up with about 24 pages, but I won't bore you with the whole list and everything else. I've just basically tried to categorize them into themes, and the first theme basically has to do with issues of legality. There's a theme that has to do with issues of economic security, health, social integration, and so on and so forth. So briefly, for example, with regard to issues of legality, I think it's very important that the region should consider facilitating access to documentation for people who are either asylum seekers or those that migrate for purposes of engaging in work. And also within countries, I think it's very important to engage with departments that are responsible for migration issues. Mostly in the SADC region, they are called Departments of Home Affairs or Ministry of Home Affairs. So I think there's need to engage with those, especially for actors or NGOs that are involved in or interested in issues that relate to refugees and migrant workers, to engage those departments and ministries to make sure that they apply legislation for documentation. So most of these departments have at least one or two regulations that relate to that, but the problem is applying the legislation. And then of course we would encourage them to advocate for implementation and also the enforcement of legislation therefore. And then there are also problems that have to do with capacity among stakeholders. So if that can be increased, I think it will go a long way in looking at issues of protecting the rights of refugees and migrant workers. And in relation to economic security, am I out of my time?
Conclude in a minute, please.
Sure. I'm just ending now. Yeah. On the economic security issues, generally, you find that most of these people that are found migrating tend to engage or involve themselves work in the informal sector. So there's need to kind of maybe increase access for them to social services, and also maybe to promote inclusive and transparent regulatory framework that will license them to operate as small traders or small businesses and so on and so forth. Lastly, on the issue of health, maybe health professionals should be encouraged to actually attend to these people without any discrimination. I recall an interview that I had with a medical professional in the Malawi, Zambia, Mozambique borderlands, who basically answered me and said, we treat everyone irrespective of country of origin because that's our mandate as health professionals. But if this can be encouraged across the region, I think it would be good. And so finally, I think it's very important for the region to go back to its protocol that promotes movement of people, and then make sure that they ratify that protocol, and then proceed to incorporate it in various national legislations. Thank you so much for listening, everyone.
Thank you so much, Dr. Nchimbi. I just remind our audience, please, to put in the chat box any comments or questions. We hope to have some opportunity for that as well. So having had some legal background to the issues we discussed, the more political science view, I think it is very appropriate that we now also hear from the people working with the UN HRC. And we have Ms. Angel Marie Dikonge Atangana, who is the Deputy Director of the Regional Bureau for Southern Africa of the High Commission for Refugees. And we are really, really privileged to have her here. We have noted at the start that unfortunately she was not able to join us at the outset, but we're very pleased, Ms. Atangana, that you are here. We look forward to your address also in this very important year of the 70 years of commemorating the existence of the UN Refugee Agency and also the adoption of the UN Refugee Convention. The floor is yours. Thank you very much for joining us.
Thank you very much, Professor, and good afternoon, and apologies for not being able to join you from the onset. I hope you can hear me.
If it's possible for your video to be shown, it would be great, because it seems my face was the only one showing, and I'd be very happy for yours to show. Thank you so much.
I just showed my face and I see myself. Now, if you can't see me, I'm not sure what I should do, because I activated the video.
We see you now. Thank you very much. You are
good.
perfectly fine. Thank you so much.
Good, thank you. But maybe if you are not, if you don't mind, I may take off the face so that you could keep the voice, because I'm having some challenges with connection. But at any rate, as you have seen me, I can speak now. Again, a big thank you for having us, UNHCR, on this August forum. I didn't really prepare a traditional statement as one would think of, but I really thought I should answer live to a few questions that I saw in your concept note, and really using my experience on ground to say I saw that your concept note is asking us, what does it mean today for a person to receive protection, to be protected from forcibly displaced, for a forcibly displaced person? What does it mean, and what might it refer to seeking solutions, especially in the context of so many protracted forced displacement, and indeed with the today's proclaimed whole of society approach, what are we looking at? So really, I don't want to bore you with reminders on UNHCR is this year, or since December last year, 70 years old, and we are entering our 8th decade. You probably can read all of that, but definitely, what does it mean for somebody to be protected, having forcibly been displaced? It means really accessing safety from a place where one has run away from harm or potential harm to one's physical integrity, or one's actually life altogether, or one's stability, if you will. And so running away, knocking at the door of a state that could receive one into the safety, into welcoming you into a protective environment that has been faulty in the first place. And that really is applicable to a refugee who would leave a country and cross an international boundary and reach that place and seek asylum. And this means that definitely the national protection, which every one of us, at least for those who are not stateless, every one of us is entitled to as a member, a national of a country, living that place where you are entitled to such national protection, and going abroad to seek international protection because indeed you can no longer enjoy that national protection. This is particularly applicable for refugees or asylum seekers in the first place. And well, in the context of internal forced displacement, that is a little bit different. It doesn't have to cross a border, and really it is not, we do say the internally displaced person, especially when they are fleeing circumstances that would otherwise also raise refugee person, would be in a refugee-like situation. And therefore, this is why UNHCR in many instances have been called upon to also deploy its expertise in regard to the persons who have been internally displaced. It means that we offer or we cater for the right of such persons to have rights, to access rights. It's in fact one having run from not applicable or no longer applicable internal protection, going to international protection. It is to look for the right to remain alive, to access.
Yes, no, but I didn't even take Untitled's charger.
That's not from my side, definitely.
Yes. Can we just ask everyone else to mute themselves, please, while we listen to the speaker? Thank you so much.
Thank you, Professor. And therefore, it is really affording the persons who has been forcibly displaced to access basic rights, including fundamental rights, starting with the right to life, the right to physical integrity, the right to food, the right to education, and you name them. So that's really what we mean for a person who is forcibly displaced to enjoy protection, be it international protection in the case of refugee, or be it in the case of an internally displaced person, it is actually to reavail themselves or to remain a beneficiary of the national protective scheme that exists on their territory. And indeed, a situation of forced displacement is an abnormality. It's not normal as a situation, and therefore we seek for it not to last forever. And indeed, in the Convention of 1951, which, as you know, is the Universal Convention, which has been adopted by member states and which really elaborate on the rights of refugees and obligation thereof, and of course the obligation of member states. This convention has particularly entrusted the task to UNHCR of indeed ensuring, supporting states to provide international protection, but also looking for durable solutions or lasting solutions. And these lasting solutions, we traditionally look at them in three main formats. The three main formats of the lasting solutions are precisely voluntary repatriation to the country that the forcibly person or the refugee has fled in the first place, if conducive conditions have surfaced, so that they can go back to the places that which they have left in the first place. And this, we tend to consider that this is always the best of the solutions, but it might not be applicable. Definitely more than 80% of refugees opt or avail themselves of this solution when possible. The second other solution that we contemplate is really local integration in the place that has welcomed them in the first place. And this in the context of today's, where really the international community has proclaimed a whole of society approach, is a more a solution that we promote more and more, also taking into consideration the protracted crisis that we have worldwide. And the third solution that we contemplate when generally the two first, namely voluntary repatriation and local integration, are not applicable, is the resettlement to a third country. And this is really a solution which benefit more or less 1% of refugees worldwide, but definitely which offers refugees a new beginning. And many of the Western countries, and thankfully, thanks to the US, Canada, and the Nordic countries, Australia, and so on, are really countries that implement this solution and that really offer a new beginning for a refugee and family. And the whole of society approach proclamation that, as you may recall, started formally, if you will, with the New York Declaration in September 2016 in the margin of the General Assembly that year, is really, for us, the practitioners of refugee matters or forced displacement matter, is really an acknowledgement, a global acknowledgement that no matter how expert we could be as an agency or even as a state for that matter, we would never match the needs, the enormous needs that are facing the world in terms of forced displacement. Today, we are speaking of more than 80 million persons who are forcibly displaced. That is more than a good number of countries considered as powerful, including the UK and you name them. And if indeed we are to succeed to fulfill the fulsome spectrum of the needs and requirements that are facing us with these forced displacement, we definitely need to do it in a synergized manner. And that is where really the whole of society approach comes from. And therefore, it need not us to be the special agencies, the UN Refugee Agency, as we are regularly called, to indeed take care of forced displacement matter. It really takes all the stakeholders from member states, be they host or be they those who provide funding and resettlement, as I just specified previously, or be they NGOs or actually the refugees themselves, because indeed we tend to consider refugees as just beneficiaries. In many situations, they are really critical assets. And we have seen it, including in this just ongoing pandemic, whereby refugee doctors and nurses have been put to contribution in order to respond to the pandemic. And this has also eased even better the inclusion of refugees altogether in the respective national responses to the pandemic. And so this is really the highlights I wish to give in this conversation. And I really would remain available to engage in any conversation and to answer any questions you might have. I thank you for your attention.
Thank you so much, Ms. Atangana, for sharing that perspective with us, with the audience. We had listened then to 3 interventions. Dr. Dorsey speaking more about the legal framework, Dr. Nshimbi speaking about the governance implications, and yourself maybe more of the experience of the UN, the High Commissioner for Refugees, also with a focus on Southern Africa. There is a small opportunity for a few questions. I note 2 related questions, and maybe Ms. Atangana, I'll go to you first and see if anyone else would like to respond. The issue is around education. Some of the participants ask, how does the right to education apply to refugees? And that is linked to the perennial issue of the birth certificate, that children are required to present a birth certificate, children of refugees or other migrants, and those may present practical problems. And perhaps we can just hear what the experience has been and what perhaps the role of your office of the UNHCR could be in this respect. Ms. Atangana, please.
Thank you very much. Definitely, as you know, education is one of our key priorities when we develop responses into refugee situations. And indeed, we promote in view of ensuring that all refugees are benefiting from the fundamental right of being educated. We promote the access to identification, including starting at birth certificate. Therefore, we work with civil registry in respective countries. I heard my predecessor talking about the fact that refugee matter most of the time are under the portfolio of Home Affairs Department in countries, and this is really applicable here in Southern Africa region and elsewhere. And therefore, we work with these entities to ensure that refugee children who are born in camp or in urban setting, wherever, have access to a birth certificate, to ensure that when time comes for them to enroll for school, they indeed can enroll accordingly. Of course, far from me saying that we do succeed 100%. We definitely have situations whereby, for some reasons, refugee children have been left without identification, without their birth being registered from the onset. And in that cases, we do put in place remedial schemes, including through foreign judiciary or public instances of issuance of birth certificate. I was just in Mozambique last year, where in fact, last December, where in fact we are working with a project which is called a legal clinic project with the university, the Catholic University of Mozambique, which is working in tandem with the Ministry of Home Affairs and our own self there, to ensure that those forcibly displaced persons, and in that particular case in Cabo Delgado, who have run away and who have found themselves without identification, including birth certificate, we can remedy the situation, and they are being issued those documents in situ through the, once they have gone through a scheme, being interviewed, and they can reconstitute the path of their birth, and then they are issued that birth certificate. We do work with sister agencies, notably UNICEF, who also does a lot in terms of ensuring that children, including refugee children precisely, access birth certificate. And so, yes, we work from the onset to ensure that the right to education would be upheld for refugee children, as we know it is paramount, including even for somehow preventing some of the crises that we see mushrooming on the continent and further fueling forced displacement in the continent. Thank you.
Thank you so much. I'm sure the other speakers may want to add something to that, but we will give you each 1 minute at the end. Let me just raise another question. Someone raised the competence of the AU Convention, the OAU Refugee Convention, to be properly applied in the absence of a strong enforcement kind of a treaty monitoring or supervisory body. I wonder, Dr. Dorsey, if you had any comments in respect of that observation.
Yes, thank you so much, Professor Viljoen. Well, I mean, one of the major weaknesses that are, you know, that are underlined by all the academics, but also practitioners of the Refugee Convention, but also of the OAU Convention, is that in fact, there is a lacking of an enforcement, a real enforcement mechanism of the two conventions. So also of the OAU Convention, oh, I'm sorry, I'm hearing, sorry, I'm hearing some.
Yes, please,
yeah.
Mute, please, thank you.
Okay, so
Cristiano, you can show your video, please.
Okay, I can show. Yes, sure, sorry. Okay, excuse me. I don't know if you heard what I was saying before, but as many refugee law academics and practitioners knows, one of the main weaknesses of the of the Refugee Convention, but also of the OAU Convention, is the lack of a formal mechanism of enforcement of the convention. That means that that is, of course, is a precise
but it seems Cristiano,
of the countries
maybe,
about the OAU Convention. Because, yeah.
Maybe you can close the video because it is bad.
No, mama, I got it.
Sorry, can you hear me now?
Yes, please proceed. Just briefly.
Okay, sorry. Yeah, sure. No, I was saying that as all the academics in refugee law and practitioners in refugee law knows, one of the main weaknesses of the Refugee Convention, of the 1951 Refugee Convention and of the OAU Convention is the lacking of an enforcement mechanism of the two conventions. And this is speaking precisely of the OAU Convention. This is a precise strategy of the African countries that, of course, they would like to keep the right for themselves to decide who admit or who don't admit on their territory. Saying that, of course, by the time, apart that I didn't mention that also also the African Charter of Human and People Rights at Articles 12 speak about a right to seek and enjoy asylum, and there's been a lot of debate on this formula. This said, of course, they are trying, for instance, above all, international organizations to make sense, to try to to help countries when they don't have in place a refugee status determination mechanism, for instance, or where they see those states to be reluctant to receive refugees, try to convince, to advocate for them to have a more generous refugee policy. But in fact, until now, for instance, the OAU Convention for Refugees has not even been object to any decision of the African Court of Human Rights, for example, until now. That's to show that it's very difficult, in fact, to give a very precise legal framework and to let all the countries accept it, all the duties present in the OAU Convention, in the Refugee Convention. And as I briefly mentioned in my example of Malawi,
yes.
UNHCR, for instance, is trying, to operate and to persuade the government of Malawi to improve their law and policy in Malawi. And the last thing, just to talk about SADC that was mentioned by my colleague, SADC has still in place this freedom of movement convention that is still not in place because there is reluctancy by several countries in SADC to allow freedom of movement. So the situation is still ongoing. I mean, it's still very difficult to give a very detailed, precise, and specific framework for that. Sorry. Yeah.
Thank you. Thank you very much, Dr. Dorsey. Let me just remind the audience that we have another session starting on the top of the hour. That will be 13 hours, 1 p.m. Central African time, and that will be 12 p.m. West African time, and obviously 14 hours or 2 p.m. East African time. So we have to, unfortunately, conclude our session in the next 5 minutes or so. But let me raise, since we have Ms. Atangana here, just the issue of the right to health in the context of COVID-19. One of our participants are asking whether in the context of vaccines being provided by the governments to presumably in the first place their citizens, whether there is a discussion what the likelihood is and what plans are in place to also ensure that refugees would benefit from these vaccines. Are there any comments or issues that you can point us to in terms of this question, please, Ms. Atangana?
Thank you very much. Definitely, yes, I can report that we have been galvanized by the very good, the high level of goodwill that we have seen from countries in this sub-region and probably further afield, whereby countries, I think, have really understood that inclusion in the context of COVID is key. Because if it were to go the other way around, i.e. exclusion of some quote unquote marginalized persons like refugees, this might not take everyone anywhere useful. And therefore, they have agreed more or less swiftly to really include refugees in the the various national responses or schemes. And indeed, this also go to the way of the vaccines. Arguably, we are still discussing and negotiating with some member states to really convince them that albeit the difficulties that are anticipated in indeed securing full access to all the potential beneficiaries to these vaccines, it should not serve as a reason to exclude refugees, and therefore they have to be included. We have a specific case whereby the country has come up, and I don't want to name or shame any country, far from me, where a country have definitely clearly come with prioritizing its nationals in view of the vaccines, but we are still discussing the rationale that refugees should be included, not least because this is also provided not in extenso in the relevant refugee convention, including the OAU convention that my predecessor was mentioning, that when you recognize a refugee on your territory, you definitely afford him or her the social benefits that you afford to your nationals. And there we are really, I'm happy to report that definitely many more countries than very few are rather inclined to indeed implement or abide by these prescriptions of the respective conventions for the benefit of the refugees. So it is pretty positive thus far. Over.
Thank you very much for sharing that with us. That is reassuring and good to know. So I think at least after our formal presentations, we had an opportunity for Dr. Dorsey and for Ms. Atangana to answer some questions. I really draw the attention of all our participants to the wonderful comments and questions and issues raised in the chat box. Unfortunately, we will not be able to go through them all or engage with them, but I think we thank everyone for engaging so very specifically. Let me just ask Dr. Nshimbi if in the light of the comments raised in the chat room, whether he would like to just also give us a concluding thought from his side.
Yes, thank you. I think it's just one word for me. It's lobbying. Various stakeholders, I think, from the grassroots up to the national level should, across the continent, actually, here I'm speaking generally, across the continent should lobby and engage governments on issues that have to do with refugees and migrant workers and the protection of their rights, particularly or especially those organizations and individuals that are committed to the welfare of these groups of people. And the reason why I say lobbying is important is when we talk about issues of enforcement and implementation of, all these instruments, you will see generally, like now, if you think about, for example, the African Continental Free Trade Agreement, it's already in motion. It was ratified last year quickly, 2018, within 2 years, it has been ratified and is in force. But when you look at other instruments which are older, particularly the ones that have to do with movement, they've been lingering on. And the question is, can we really say that there's no capacity in government circles or things like that? That's not the issue. The issue is that they need to be shown the importance of speaking to the dignity and the rights of migrants, and also to show them that there is benefit in actually promoting the well-being of these groups of people for the nations and for the national economies. I think that's my point here.
Thank you so much. So once again, thank you to you all for being part of this discussion. Thank you to our three speakers. I really invite everyone in about 10 minutes, the next session in this virtual conference will start. It will focus on local integration in Southern Africa. I think that's obviously kind of arising from our talk and our discussions in this particular session. So we maybe in conclusion just want to thank you all, thank our speakers, and thank Dr. Romola Adiola, who has been helping us in both the sessions to bring the speakers together to conceptualize this. She heads and coordinates the Global Engagement Network on Internal Displacement in Africa, Genida, and she's with us here in the center. And then at the center for the technical assistance, we thank Yolanda Boyson and Taruna Naidu and everyone else who assisted. Once again, this is just the start of a conversation. We thank you for being part of this part of it, but we hope that we will be seeing you very soon when we resume in the follow-up to this, where we will look at local integration in Southern Africa. Thank you, and see you soon.
Thank you so much, Professor Viljoen.
Thank you.
Thank you. Once again,
thank you so much.
Speakers, thank you so much to the three of you. We really appreciate your participation.
Thank you so much.
Thank you for
Most welcome.
Thank you.
Thank you. Thank you.